Mr. Speaker, I rise on a point of order, and the point of order I'm raising is with respect to Rule 2.2, Recall of House, which states, if the government advises the Speaker that the public interest requires the House to meet at any other time because of an emergency or extraordinary circumstances, the Speaker must advise the members that the House is to meet at the time specified by the government. The House must begin to meet at the specified time. The rules of this legislature, including Rule 2.2, which were agreed upon by all parties in 2002, included a sessional calendar and provision for emergency sitting if needed. They were created to make it easier for the people in Manitoba to participate in their government. As the government House Leader at the time said, and I quote from Hansard, December 4th, 2002, some of the important aspects of the rule changes included a greater respect for the public. He also said that the change speaks to the need for greater public accommodation. I raise this point of order to ensure that we achieve what we aimed for in 2002, the greatest possible respect for the people of Manitoba, for we are their servants. My concern is that the government has failed in calling this emergency session to begin today, that it has not been specific about the nature of the emergency or the extraordinary circumstances. This is very important because Rule 2.2 is very specific in saying there must be an emergency or extraordinary circumstances. Mr. Speaker, there's a lot going on in the legislature recently, and not everything is an emergency. A session which is organized an emergency or extraordinary session is different from a regular session or an extension of a regular session, and this has been established in precedent and through past practice. While such precedent may not be a part of the rules specifically, precedent is a very important aspect of our parliamentary system. Mr. Speaker, under the rules adopted on December 22, 2002, we've had the legislature recalled only once for an emergency session, and that was on June 23, 2003. On that occasion, it was made very clear that the government had a requirement to make clear the reason for calling the emergency legislative session. The then Minister of Justice and Attorney General said, and I quote from Hansard, I am directed by His Honour the Lieutenant Governor to inform you that he will not declare the causes of calling this legislature until a Speaker has been elected in accordance with the law. Now, Mr. Speaker, the circumstances of the present emergency sitting and the recalling of this legislature are somewhat different from those which occurred in June 23, 2003, but aspects of what occurred for that day are certainly very relevant to today. Before the sitting on June 23rd, the government had clearly communicated to the Liberal caucus of the day and the Conservative caucus of the day the reasons for the emergency recall of the legislature. It was specifically to deal with several items, one of which was an urgent debate on a matter of public importance on the bovine spongiform encephalitis situation, a very urgent, indeed, emergency matter at that time. Furthermore, before that matter was dealt with, two speakers from the government side of the House and both opposition caucus House leaders had an opportunity to speak in the House directly. Sorry, that's both opposition caucus leaders, not House leaders, had an opportunity to speak in the House directly on the reasons for the recall of the legislature. Because of the emergency or extraordinary nature of that sitting, there was a discussion among House leaders as to precisely what would be the essential components of the emergency sitting, and there was unanimous agreement among all parties to proceed with the emergency sitting because all MLAs realized that there were indeed extraordinary circumstances on that occasion. Mr. Speaker, no such process has happened this time. There are also considerable precedents going back many years for special or emergency sessions in the House of Commons in Ottawa. These have been called for outbreaks of war, exceptional economic conditions, the disruption of railway transportation facilities, and severe international events and hostilities. They've been very specific, and the nature of the emergency to be dealt with has been clear. Next, Mr. Speaker, I want to comment on what precedent has illustrated is not a sufficient requirement for an emergency or extraordinary sitting of the legislature. First of all, the completion of the budget process, including the estimates, concurrence, and budget-related bills, like the Appropriations Act, the Loan Act, and the Budget Implementation and Tax Statutes Amendment Act bill, are clearly not emergency matters. In 2003, these matters were completed in the September sitting, and bills received royal assent on September 30th of that year. In 2007, these items were completed in a sitting which lasted through September, October, and November of that year. It was not completed until November the 8th. So clearly the failure to complete the estimates on a wide variety of other bills is not an emergency. Next, Mr. Speaker, I would like to review what has happened this year. Last week, on Tuesday, June 11th, I asked the Premier, and I quote from Hansard, which bills will he be designating as emergency bills to be completed during the emergency session expected to start next week? The Premier replied, and I quote, all of our bills are priority bills, Mr. Speaker. Clearly, in spite of what the Premier said on Tuesday last week, based on the precedent set in 2003 and 2007, not all bills can be considered emergency bills. Certainly, the majority of bills before this session could wait until our regular sitting time in September to be debated and dealt with. In fact, one might argue that by precedence, this could even be the case for all of the bills. Mr. Speaker, because I was concerned last week about the nature of the emergency sitting, and it didn't seem logical to me that everything is an emergency, I spoke again in question period the following day, Wednesday, June the 12th, saying, and I quote, Mr. Speaker, yesterday the Premier said, in terms of the emergency session, that he was putting a priority on all of his bills. Quite frankly, this quote is misleading Manitobans to understand that the impending emergency session after this Thursday will continue as if it were just a regular session. The rules of the legislature are clear that calling the House outside of the sessional calendar is for emergency or extraordinary circumstances to deal with emergency measures. When will the Premier tell Manitobans, and I asked, which bills he considers emergency bills to be completed in the emergency session? And the Premier replied, and I quote, all the bills we consider to be important, and the budget we consider to be important. Mr. Speaker, I note, Mr. Speaker, the Premier said, and what was important, not what was an emergency. And these are two very different words with different meanings. Important and emergency are not the same. I remain concerned that no specific reason, hence no direction for business, had been given for the emergency sitting. And so I asked last week, once more, Mr. Speaker, and I quote, I asked the Premier to be honest about this, acknowledge that we're going to be in an emergency session, and tell us what emergency measures he's going to be dealing with. The Premier replied, and I quote, we're very eager to carry on the work of the legislature, both on the budget side and on the bill side. Mr. Speaker, the remarks of the Premier in response to my questions can only be interpreted to indicate that the Premier was talking about carrying on the regular work of the legislature rather than dealing with a specific emergency or extraordinary circumstances in this emergency sitting, which has been called starting today. Mr. Speaker, there are two bills, which in my view the government might suggest are emergency bills, and I would like to discuss these two bills as examples of why they should not be considered emergency bills. The first of these is Bill 20, a bill which removes the requirement for a referendum before the PST is raised. This might be considered an emergency if the passage of Bill 20 was necessary before July 1, when the increase in PST comes into effect. The government itself has argued many times in the present legislative session that there is no legal or other requirement that Bill 20 be passed before July 1, however. Thus, the passage of Bill 20 is not an emergency, and it can be adequately addressed in September or even November, as previous bills have awaited passage in 2003 and 2007. The second bill which might be considered an emergency is Bill 18, the bill which provides for measures to prevent bullying in schools. I believe the government may have even indicated that it would like Bill 18 to be passed before school opens in the fall. This might be understandable, but what is not understandable then is why the spring session wasn't called earlier, or the debate and passage of this bill was not made a priority during the regular spring session. Indeed, Bill 18 has only been presented for second reading debate on 3 occasions: December 6th last year, May the 6th, and June 10th of this year. Even though I, like the Premier, consider this an important bill, his government's actions to date are not consistent with prioritizing this bill as an emergency bill. Thus, I must conclude from the government's own actions to date that they don't consider the passage of Bill 18 before September.
I regret to interrupt the honourable member for River Heights, but I think he's getting into the debate of the substance of the matter, and I would ask him to provide some clarification to the chair on what rules or procedures of the House might have been breached. I'll offer that as guidance to the honourable member for River Heights. The honourable member for River Heights.
Yes. Mr. Speaker, I am speaking specifically to Rule 2, Sub 2, the recall of the House, which states that if the government advises the Speaker that the public interest requires the House to meet at any other time because of an emergency or extraordinary circumstances, the Speaker must advise the members that the House is to meet at the specified time. We are being recalled today under that clause, 2 Sub 2, as the government indicated last week, and therefore let me conclude my remarks specific to that issue. That the government, in using this clause, must demonstrate that there is indeed matters which are of an emergency nature or require extraordinary circumstances. There may be other matters that could be considered an emergency. Kim Edwards is on a hunger strike in front of the legislature. She's raised important issues with respect to child and family services. The government has not shown to date an inclination to deal with these matters, let alone to treat them as emergency matters. The government needs to specify what matters are emergency matters. Mr. Speaker, I am keen to get the business of the legislature done, but in order to do so, the business of the legislature, and to do it well, we have the rules of the legislature to follow, including Rule 2.2, a rule which was designed specifically to enable governments to deal with emergencies. Under Rule 2.2, the sitting can only be called for emergency or extraordinary reasons. And to date, the government hasn't indicated what matters are emergency matters, and those that the government has mentioned to date by precedent in this chamber are not matters which require an emergency or extraordinary sitting of the legislature. Mr. Speaker, the legislature can work most efficiently and most effectively to address the emergency and extraordinary circumstances if the government makes very clear exactly what is the emergency, so those of us in the opposition parties can help to deal with this emergency. Mr. Speaker, as I've indicated, I'm concerned that proper procedure has not been followed with respect to Rule 2.2. And if that proper procedure is not followed, we might set a precedent for the abuse or overuse of this rule in the future. There are various options that could be offered to correct the lack of proper procedure. The government could immediately indicate what this emergency sitting is about and define what is an emergency and what is not an emergency. Mr. Speaker, you could rule that because Rule 2.2 has not been followed properly, that this sitting cannot occur in the start of any emergency sitting. We'll have to wait until proper procedure has been followed. Or, Mr. Speaker, you could rule that the ground put forward for the sitting don't represent an emergency and the government will have to wait until the normal sitting time in September. Thus, Mr. Speaker, I would ask you to consider this point of order, and to rule that grounds for this emergency or extraordinary sitting have not been provided, and therefore recalling of the legislature is not valid and should be revoked until such time as the government clarifies precisely what is the emergency or extraordinary circumstances we are to be dealing with in this setting. Thank you, Mr. Speaker.